Hi, good evening. My name is Niharika Ghadke and I welcome you to a new session as a part of YLCC's Legal Career-A-Thon series, where we have experts to guide you about different practice areas in law. Today we have with us Mr. Abhinav Shrivastava, sir. Welcome, sir, and thank you so much for joining. Sir is here to guide us on career as a litigation lawyer. Sir has graduated from NUJS Kolkata and has pursued his master's in criminal law and forensic science from Nalsar, Hyderabad. He is currently a practicing advocate at the High Court of Madhya Pradesh, along with being a panel lawyer at the Oriental Insurance Company Limited and at Northern Coalfields Limited. He is also a mentor and advisor at the IDI Scholar Development Team and has been a member of the WHO Legal Development Program in India. If time permits, we shall have the questions of the audiences at the end of the session. So I request the audience members to pin down their questions in the chat box. And I also request everyone to mute themselves so that there is no disturbance throughout the session. So would you like to say anything to the audience before we delve into the session?
Can you please tell me the profile of the audience, like who are the audience, whether they are students?
Most of the audience is students, and if anyone would like to go ahead who are not students and would like to introduce themselves, they can go ahead and unmute themselves and say. But mostly the audiences comprise of the students who are basically in their first, second, and third year of the law school, and then we have other students as well.
All right. Shall we go ahead?
All right, sir. So if we can directly delve into the session, or we can, if you have anything to say to the audience, you can go ahead.
I think I can directly go into the session.
All right, sir. Not a problem.
Yes.
So,
hello,
sir, how
everyone.
does... Right, sir.
Yes.
So, right, sir. So how does your typical day look like as a High Court lawyer, and what are some responsibilities that only you can take care of?
See, as a practicing lawyer, the typical day is not exactly the same anywhere. You are not going to have same kind of day on a regular basis. That's because the cases which you deal with are different, and the clients you are dealing with are also different. For example, suppose today if client comes to you asking that his brother or sister has been arraigned and is accused in one of the criminal cases, for example 302, and he wants you to file a bail application on his behalf. So the kind of client you are dealing with is a person who is in jail, and apart from the client who is in jail, you will also have to listen to the family members who are coming to you, because he will not come to you. The family members will come. So suppose you are dealing this kind of case in a particular day. Next day you are dealing with a civil case or a criminal case or in a criminal trial. So the kind of work which I deal with, or which most of the litigating lawyers deal with, is different. You're not going to have a same day on a regular basis. And the responsibilities which I can only take is as a lawyer when I come across the court and before the judge. When you are before the judge, you have to have the confidence or the ability to answer the questions which the bench is asking to you. You might be prepared with your brief or the case beforehand, but there are some cases or the questions which will come only when you argue the case before the High Court. For example, you are arguing a criminal appeal or a bail application or any other case. You might have prepared the facts, the law, and the probable questions which a bench or the judge, honorable judge, can ask. But you cannot prepare all the questions which can ask. So you should have a basic framework of the case around which you can work out. That's what we say, thinking on your feet. That's, if a judge is asking, you have to think on your feet, and that I think distinguishes a good lawyer from an average lawyer. For example, if a judge asks you something and if you are stuck there and thinking about it for a long time, the judge will not wait for you to think for that moment, because he will have some 500 cases or 600 cases listed in a day, which he has to complete or she has to complete within 5 hours. So most of the time you can get only 5 minutes, 10 minutes, mostly 5 minutes, not more than 5 minutes for a case. So it's the ability which only a lawyer can take on behalf of the client, because the client has endowed that responsibility on you that you cannot share with anyone unless there is an accept consent of the client.
All right.
Yes, yes, I think I've answered this question.
Yes, sir. So, sir, you have graduated from NUJS, which is one of the top NLUs, where freshers usually prepare for the corporate roles. So, what inspired you to step out of the comfort zone and build a career in litigation? And what are your core specializations?
I think when I was in second year of my college, I was reading the biography of Nani Palkiwala. It's a great biography. You should all read biographies. It's written by M.V. Kamath. It guides you to the life of the most distinguished lawyer which India has ever had, and the change which you can make by being on the ground and being the part of one of the three important organs of the state: executive, judiciary, and the legislature. If you are a litigating lawyer, you are directly involved in core area of law where you are a part of the judiciary, and you can be a part of development of the law which is done by the judiciary. So when I was in second year, I also interned under Mr. Ravindra Shrivastava, senior advocate in the Supreme Court. This was my first internship, and there I saw arguing uh, most of the leading lawyers at that time. And thereafter, I thought that this is the profession or this is the field which is made out for me, or that which interests me, which creates an interest. And thereafter I never, and it's very ironic that I never did an internship in a corporate law firm. Most of my internship were litigation based, under Mr. Justice S.J. Mukhopadhyay, under Mr. Gopal Subramaniam, under Mr. Iqbal Chagla. And the more internships I did under these persons, these leading lawyers, the more interest I had in this profession and the kind of work which I can do. It is also about the interest. A person might be interested in a corporate job, and another person might be interested in a litigation job. But there is no harm. It is not like corporate versus litigation. It is like what interests you, where your interest lies. You might not be interested in litigation. That's all right. You might be interested in corporate. But you have to find your calling, where you are interested in. So I found my interest in litigation by reading the biographies of, including the MC Chagla, and Fali Nariman and other biographies, and the experience which I had under the lawyers, reputed lawyers, leading lawyers of even today they are the leading lawyers. They guided me through this profession. Now, the coming to the specialization, I practice in Jabalpur. So again, the core specialization which you do does not depend on your interest per se, especially if you are not litigating in a place like Delhi, because, or Bombay. If you are litigating in some state high court, for example, Allahabad High Court, Jabalpur High Court, Rajasthan High Court, for that matter, so you will get traditional kind of litigation, mostly civil cases and the criminal litigation. Corporate litigation is not something which you will get here. My area of specialization mostly relates to criminal law and the constitutional law, including the writ petitions. I do trial work, and apart from that, I do every kind of work. Like the work profile includes trademark or NCLT work, but the most of the work which we deal with our chambers is the criminal law and the writ petitions and the constitutional law cases.
Sir, can you help our audience understand the different kinds of work available in the field of litigation? Because the common perception towards litigation is that you always have to choose between civil law or criminal law. So can you explain more about what else does litigation have to offer and where should one begin with?
I will say that this traditional demarcation between civil law and criminal law is more or less gone in today's time, because civil law is a very diverse field. When you say about the commercial litigation, it also comes under civil law. When you talk about the writ petitions, so that also come under the civil law. Now criminal law is also something very different nowadays. Now you cannot confine yourself to a particular field, especially when the role of technologies in today's time is rampant. For example, you are dealing with a criminal case, however it has the outlinings of technology, corporate civil law, for example, the corporate fraud, economic offenses. Now, if you're dealing with the economic offenses, that requires you to have an understanding of criminal law, civil law, and technology law. For example, bank fraud. If a money is gone from your bank account, if someone has defrauded you of an enormous amount, for example, 1 CR, 50 lakhs, 2 CR, and you are dealing with that kind of area. So I will say that one should not keep in mind this traditional demarcation between civil law and criminal law, and understand this field of litigation as a dynamic field where you will be required to have understanding of every kind of law, because you do not know what kind of case you are going to deal with. You will deal with civil law again with outlinings of criminal law or the tech law or IPR law. You never know that. I have been dealing with cases of the economic offenses. Our chamber specializes also deals with economic offenses. It's a very particular niche field where you are required to have understanding of different kinds. Now, the different kind of work which is available in the field of litigation. See, litigation not only involves you going before the court only and arguing, it also requires the background work. The background work starts from the moment the client comes to you. The moment the client comes to you, you have a client conference. You try to understand what are his or her needs. Suppose if she has been terminated from the job, so you will try to understand what kind of job that is, what kind of rules which are applicable to that job, what is the nature of the termination. So that is the first stage where you do the conference. Once you're done with the conference, you analyze the law, the forum and the remedy which your client can avail. It can be in the form of the writ petition, it can be in the form of a civil suit, that you have to take a call after doing the analysis. Once you're done with the analysis, you do the drafting work based on the legal research you have done. Your drafting should be symmetric to the law or the research which you have done. You cannot just draft anything, you cannot just write there anything. Your drafting has to have legal basis. If it does not have the legal basis, it will not be entertained by the court. So once you have passed these stages, then comes the stage of the court, where you argue. Now you argue on the basis of this background work. Now there are people involved in every stage of this work. For example, there are legal researchers. There might be a person who is more interested in research and the drafting. So there are people who confine themselves to the research and the drafting also. These are major kinds of work which you deal in the litigation field.
Right. Sir, are you a first generation lawyer? And what are the qualities according to you which make a litigation lawyer stand out from others? And how did you incorporate those qualities in yourself?
I am a first generation lawyer per se, but there have been people in the legal field in the family. Uh, my father was serving judge in the High Court in Madhya Pradesh. Brother and sister in law also belong to the legal field. My wife is also an advocate with me, so we do work together. So far as litigation work is concerned, yes, I am the first person in the family who has set up these chambers. There is no, I will not say there is a particular quality which make a person stand out from others and which one can always follow. So there is no particular path which one can follow. A road or the path which a person has to create is different according to the circumstances which a person has. The road which another person has taken might not be suitable for you. You take guidance from that path, you take some positives from it, but you create your own path. Don't follow anyone blindly. I will suggest that don't follow anyone blindly. If a person, if a lawyer has succeeded in the field, for example, a senior advocate who has aged 60 years, now the circumstances which were there when he was a young lawyer were very different. There was no internet, there was no e-library, there was no telephonic communication, and there was very limited transportation amongst the cities. There was no virtual courts. You could not have done the VCs. So the path or the which those lawyers have taken, or even the lawyers amongst you have taken, might be different. So there is no particular quality which will make you stand out, and you will have to adapt to the circumstances which are around you, how you play with it, how you're playing with the resources which you are having. It's all about the resources and how everyone will get the resources. One will get more, one will get less, but how you play with them, it is the quality which you should have. And you should not focus on now some, see, there is a lot of distraction in this field also, because you will not get uh, paid for initial years, so you have to struggle. Now in metros in like Delhi, you get paid, even the young lawyers get paid, but in most of the other high courts, people don't get paid. So there is another thing that you will have to take. You will have to have support of your family also for at least a couple of years, so that you can focus on your work. So I will suggest that the quality is about your ability to play with the resources which you have around you. If you are able to play with that well and smartly, and it is not only the hard work which will matter, it will also the smart work. You might be working 12 hours a day, but that does not matter. Suppose a person is completing that work in half an hour, and you are completing that in 12 hours. So the person who is completing it in half hour, he will have more time to complete more work, which you are doing in 12 hours. So that will make that lawyer stand out, because he's so act smartly in anything in your life. And these are the qualities which you not focus only when you come into the profession. These are the qualities which you focus on your daily life. For example, in your classroom, amongst your friends, any work which is allotted to you, any small work. Suppose you have to send an email. Suppose you have to suppose you have to arrange your almirah. These are the small things which you create or on daily basis. So don't only focus on the larger picture of the litigation, the qualities are general qualities. Your general qualities make you a will help you in litigation also. Yeah.
Right. So, sir, irrespective of one's core area of practice, what are the basic laws which the students aspiring to be litigation lawyers should know by heart, and how should they start their preparation from the field for the field from law school days itself?
students should write in the big words procedural law. You should know about the procedural laws by heart. CPC, Code of Civil Procedure, Code of Criminal Procedure, and Indian Evidence Act, and substantive law such as Contract Act. These are the basic law. Wherever you go, High Court, Supreme Court, this is the basic procedure. For example, you are focusing on whether a person has committed a murder or not. You are focusing on the substantial law, but that will come into later. That will come into picture at a later point of time. Now the stage comes at with the registration of the FIR. So you should know how the FIR is registered, what happens after the FIR is registered, what are the steps in this investigation, how the investigation is done, and what happens after the investigation, how is the charge sheet filed, what happens after the filing of the charge sheet, what are the kinds of the trials which take place. There are 4 kinds of trials. So what are the kinds of trials which take place, and how each of the kind of trial take place. There is a different procedure for each of them. So, and so far as CPC is concerned, suppose you are filing the civil suit, so you should know how to draft a plaint. There is a format of the plaint and the content which should be included, provided in the orders. So CPC is a very large subject, and it's only a section 1 to 151. It's only basic, but the orders which are provided in the CPC are more important, because order provides you the procedure which you have to follow, and the limitation within which you have to file everything. For example, you file the plaint, and if you are a defendant, within what time you have to file the written statement. In commercial before the commercial court, the limitation is even stricter. So I will suggest that the students, even when I was a law student, there was very minor focus on the procedural law. But when you will come into litigation, if some of you choose to be a litigating lawyer, procedural law is something you should know and you should learn by heart. And do not just do not just mug it up. You have to understand it. You have to understand the procedure. Understand it like a story. What agar, if an FIR is registered, what happens? Where is FIR provided? What provision? What is the content of the FIR? Who registers it? If an FIR is not registered, then what are the steps which you can take? Before which authority you can go? What are the contents of the charge sheet? What is the case diary? What are the cases which can be tried by a magistrate court, JMFC? What are the cases which can be tried by a sessions court? So I think they can start their preparation for the field of if they are in law school, so they can just start going through the basics of CPC, CRPC, and Evidence Act. They can start with that.
Right, sir. It is assumed that negotiation skills are necessary only for the corporate lawyers. But do you think that even litigation lawyers require negotiation skills, and in what aspect are they important?
I think that will be a misconception. When you argue before the bench, before the judge, you negotiate with the judge. You negotiate with them. You negotiate your case with them. I am talking about the core courtroom cases, not outside the courtroom cases. So there has to be a dialogue. When you are presenting your case, it is not something that you cannot be a rigid spectator there. You are basically having a dialogue with the judge. And if you are making the bench or the judge comfortable with the fact that you are not an aggressive lawyer, rather you are a negotiating lawyer. So I think negotiation is a skill which is required everywhere and even in this field. Suppose you went to the court for asking a larger relief, but the bench is not inclined to give you the larger relief, but it is asking you whether you are comfortable in settling with the smaller part of that relief. So did not get the larger relief, but you got some relief for your client based on the negotiation and the dialogue, I would say dialogue with the bench. I think that is a misconception that this skill is required only for the corporate lawyers. It's very much required in this.
Right. Sir, you have also been a part of the WHO Legal Development Program. So, how did you contribute there as a litigation lawyer, and what were your key responsibilities? Also, how can the younger generation be a part of such programs?
So far as them being a part of it is concerned, you have to keep searching on the opportunities which are coming. You will have to search that on daily basis on Google. Google is available with everyone. Just Google, and there are various websites, and you just have to keep searching on the opportunities. That's the only way. There is no particular trick which can be told, especially in today's technological time when you have such an enormous amount of information. You will get some opportunity. Everyone will get some opportunities, and one has to tap on it at the correct point of time, that I would say. Now, as a litigating lawyer, there were a couple of them with me in this program. So our program basically relate was related to making suggestions on the issue of road safety, the Motor Vehicles Act amendment which was coming, and we were to make a report of it and submit it to the government. And there were certain we also had a tie up with some state governments on how to make road more safer because of the fatalities which were taking place on a regular or an annual basis. So how to make it more, whether fines has to be increased, what are the responsibility of the traffic police, and what laws can be brought in, and how can they be modified to make the roads safer. So we worked on that area for I think more than one year, and these were the responsibilities which were.
What are the key parameters you look for in your interns, and what, according to you, makes or breaks the professional career trajectory in litigation in the longer run?
And there is no particular parameter which I look for the interns. I know that they are law students. They don't know much about the field. And if I expect them to be a very experienced person, then they are not interns. The term intern says it all. I take interns from everywhere and from every college. It doesn't matter. Even if you don't know something, I take interns who are who are clueless about anything. So it's our job to make them understand. Some interns do it better than others, but that is according to their understanding of the dynamics when they come to intern. Now, what makes or breaks the professional career trajectory in litigation is the patience. You need to have a great patience in this profession with everything, with the amount of money which you are getting in the initial days. That is the major hardship which you will face. You will feel that no, I'm not getting cases. How will I get the cases? You will get cases if you stay in this profession. When I joined the chambers of my senior, Mr. Anil Khare, senior advocate, so there were four people who joined with. There were two other people who joined with me. Two of them left the profession within a year, mostly because of the fact that how you are going to get the cases. That is the major question mark which comes to everyone's mind. How am I going to get the cases? And second, how am I going to earn the money? Now, when you graduate, you have two things which are in front of you. You do the job where you will get the money quickly, and you have the litigation where there are things are uncertain, where you need to spend a couple of years before you start earning fairly well. So I will say patience is the most important thing which breaks or makes the professional career trajectory. If one does not have the patience, then litigation career is going to create a lot of problems. One has to have, especially when you see, suppose you have spent 2 years in this profession and you see your colleagues earning and buying things and you cannot, you are just living on the subsistence allowance. So if you are not, if you focus on these things, and if you're not focusing, you need to have focus also, that you are in here in this profession to make a career. Maybe you will start late, maybe you will start after 5 years, but if you start well, then there is no ending in this profession, there is no limit to which you can succeed. Have patience and focus if anyone wants to join this profession.
So, sir, as a litigation lawyer, while juggling multiple cases, how do you take time to upskill yourself and maintain sanity in this hectic profession? Also, you perceived a higher degree from NALSAR. So, how did that contribute to your growth?
I think it's very difficult to maintain the work life balance in this starting in this profession. You have to work it out, and if you are dealing with multiple clients, you are dealing with multiple draftings, so you have to have a ability to arrange things. For example, you have 10 things lined up in a day, so you should note it down at least a day before in a diary, that these are the 10 things which I have to do. And the next day you have a list of the items which you have to complete, and you can complete it in a linear fashion or a non-linear fashion, which you have to, and which you have to take a call based on your arrangement. For example, you have to go to the court at 10 a.m. and you will come by 5 p.m. So you can complete your court work between this time, and you can also do the drafting work between this time, because between the court hours you will also get free time when you are waiting for the, we call it waiting time. Suppose your one case is listed at serial number 10 and another case is listed at serial number 50, so you will have waiting time between serial number 11 and 49. So you can use that waiting time. If you want to use that waiting time, you should have the ability to be handy with the gadgets. Now, if you are comfortable in carrying iPad or any tablet in the court on which you can do drafting, so you can make use of this time. If you're not having that, so you will wonder what I will do with this waiting time, or I will just roam around in the canteen or just roam around chatting with the people. Now, again, you have to play with the resources which you have, and how you play it depends on you. How smartly you play it again depends on you. So we say that we don't have time to do things, but I think that is a huge lie, because people get time. Time is 24 hours for everyone. I i never do work after 9 p.m or 9:30 p.m. We have made it a rule that after 9:30 p.m or maximum 10 there is no work. You need to have your family life also, you need to have your personal life also. Just understand that work is only a part of your life, it is not your life. People confuse work with life, that is not the case. If you're not having the balance between it, it is going to harm you in the long term, it is going to harm your health. We should not we should not promote. I personally don't think that if you are working for, if you're sleeping for 3 hours, 4 hours a day, it is a matter of pride. I don't think. I think it is a thing which shows your inefficiency, that you are not able to complete your work within the designated time. We waste so much time in roaming around and on unnecessary things, and just uh, exploring the apps which we have on mobile, we can make use of that time and complete our work in time. So we try to do that and try to maintain the balance. And so far as the degree is concerned, I have not completed it yet. I have not been getting time. Again, in this hectic schedule, I have not been getting time. So it is still pending. I have to complete it. It is still pending. Yeah.
Right. So what do you think is the most important aspect of client communication and counseling? And how do you maintain transparency and make sure that the client is on the same page as you are when it comes to giving directions to the cases?
I think the most important aspect of client communication is the ability to listen. Again, patience. There will be clients who will say unnecessary things or things which are not in the context. And if we get irritated of it, then that is our inability or our ineffectiveness to deal with the client. Because we have to understand that if a person is coming to you, understand this, no happy person is coming to you. A person who comes to court or who comes to you will always be an unhappy person. He is not going to come to you to share their happiness. So there will always be problems in their life. Someone will be in the jail, someone is going to in the jail, some person in his family has been murdered, and his amount has been there is a breach of the contract between the person. The other party is not paying the amount, so there will always be a problem. So the ability to understand their problem, so they will tell you 100 things, thousands of things. Now it is your ability how you are able to identify the key points out of those things. You have to separate the wheat from the chaff. You have to separate it. He will tell you unnecessary things, separate it, and the necessary things you keep with yourself. And that you will get only when you have patience and the ability to listen and answering their queries in a very patient and a polite manner. People will call you at 11 p.m., 12 a.m. My clerk complained to me a couple of days ago that a client called him at 1 a.m. asking him about the status of the case. Now you can choose to ignore his call or choose to ignore the calls, but understand that there can also be emergency in some situation. So if you are ignoring the calls, so you don't know why that person is calling to you. You will only get to know when you attend that call. So listen to them. Just listen to them, and that will make them comfortable. That lawyer is listening to me. That lawyer is not ignoring my calls. That I think is a very important part in this profession, and I think for the daily life, for that matter. And transparency, I think is very important. The steps which you are going to take in the case, you and your client should be on the same page. If you are not on the same page as that of your client, then there are going to be problem because you will not be acting on his or her instructions. You are representing the client. You cannot you cannot act outside the instructions which have been given to you. Maybe those instructions are bad, maybe those instructions are good, but you have to keep in mind that those instructions are not unethical and are not illegitimate. If he will ask you n number of things to do, now you have to tell them that these are the things which I can do as per the professional standards which have been laid out by the BCI, and these are the things which I can do, and other things which I cannot do, you have to tell him straight away. Now there will be clients who will come to you and ask you, are you taking the guarantee to win the case? Everyone is going to come to you. Are you giving me the guarantee that you will get the bail? Are you giving the guarantee that you will get the acquittal? Are you giving the guarantee that you will win the writ petition? No. Now, we do not practice it, and so far it has turned out well for us. But giving guarantee is not something which should be done. Again, that transparency has to be maintained with the client, because he might go away from you today, but if he is getting the same from other place and if he is not getting the result, so he will have in his mind that yes, that lawyer told me the correct thing, because this profession is based on the trust. And the lawyers do not have a very good image amongst the public, that they think that they are very cunning and they do what not. So it is a matter of trust also. The clients and the public should trust you also, because you are an intermediary between the public and the court. If you do well, you do well for the client or for the public or the general matter. There will be clients who will not be able to pay much to you. Now you can just choose to make them go away, but that is again your call, because not everyone can pay. Some clients will pay you more, some clients will pay you less. But if you're focusing on the money aspect, then again there is going to be a problem, that I will set this standard with everyone, then it is going to create a problem. And it is very important that you and your clients are on the same page.
Sir, it is said that litigation pays in peanuts and the growth is very stagnant in the initial years. So, what do you have to say about this? And what is the motivational factor to continue with the grit?
I think litigation does pay you in peanuts in the starting, and the growth part I do not agree with. Growth again depend on how you play with your resources. Some people take 15 years, some people take 3 or 4 years. Even the first generation lawyers I have seen, they take some will take 3 years, some will not be able to establish even in 20 years, 25 years. So the growth is not stagnant, it depends on your ability. And your ability and your competency will be appreciated by the judges within the community. People will appreciate it, but you have to be you had to have the you have to have the ability to play with the resources which you are having. Now the motivational factor, there is no motivational factor, again, which I had said in the starting. You need to have the patience. Patience is the keyword in this profession. Now there will be many points in this profession where you will be demotivated. Suppose you are working. I did not get any work in my seniors chamber for 1.5 years. Only minor things I got for 1.5 years. But after 1.5 years, I got substantial work, and that is continuing even after I left the chamber. Established independent practice, that is continuing. So if I had thought that, oh, listen, that I am not getting any work even in the chamber, in the office for 1.5 years, that is the breaking point. That is the moment then you will start looking for it. It would have been better had I have joined a law firm, had I have prepared for the judiciary or the civil services. These thoughts will coming to you. Now again, the parents will ask you, what is happening? They will ask you, what is happening? What are you earning? How much did you earn this month? So all these factors will make you demotivated. So it's very important that you keep yourself going and have patience, that just stay focused, do the work. uh, you must have known the name of H.M. Sirvai, the great constitutional lawyer, uh, who appeared in Keshwananda Bharti case against Nani Palkhiwala. No, H.M. Sirvai represented the government and Nani Palkhiwala represented the petitioner. Now, it is said that he did not get much work for 10 years in initial 10 years. And MC Chagla, if someone has heard, he was the first Chief Justice of the Bombay High Court. He remained the Chief Justice for around 10 years. Then he was the Union Education Minister, Union Foreign Minister, Ambassador to UK, US, High Commissioner to UK. So there were points in his life when he wanted to leave the profession because of the fact that he is not able to run the family. These are the breaking points which you will have in your profession, and how you how you deal with it, how you face it, will make or break your career. And it's not the ability only in your profession, it's the general ability in your life, how you deal with the situations. If you have the ability to deal with the situations, you will continue and you will progress. If you do not have the ability and if you give up, then there will be a problem and you will break down. People do that. This has happened with many people. I have seen them, but that is the breaking point which you have to deal with. There is no particular formula how you are going to deal with it. Patience is the key, but how that patience is going to work out for you will depend on you.
So sometimes in court cases, there is involvement of certain higher authorities and influential people. So in such cases, how do you keep your calm and stick by the law and present yourself in court?
See, there will be high profile cases in your professions where in the opposition there will be certain influential people who will try to lure you, who will try to do a number of things. How you maintain your integrity and your professional standard will depend on you. Again, that is not the quality which you will attain once you start the profession. That is the quality, that is your basic quality. How you get influenced by the people. And if someone big is involved, whether you get influenced or not. Uh, I was listening to one of the interviews when I was in college, that what everyone must have heard the name of Mr. Harish Salve. So how he deals with the people. So in that interview, it was told that even if he meets with the people like Mukesh Ambani, so he does not treat him as someone with awe. You have to feel, however the big the person is, if he is coming to your chambers, you have to deal with him as a normal person. Suppose a senior IAS officer or for a judge for that matter may come before you as a client. So you don't have to feel out of proportion for it, or you have to understand that you are dealing with any person, howsoever big authority, howsoever influential person that person is coming to you as a client, and you have to deal with him or her in that manner. I think it is that ability which will make you stand out. You do not have to give into the pressure, even if legal opinion which according to you is against that person or is not in accordance with what that person is saying, you should tell him, because that is the ability or that is the quality which will help you in the long run.
So if anyone is interested to unmute themselves and ask any questions if they have, they can do so. So I personally have a question.
Yes.
So we want to be able to quickly resolve cases, but also want our clients to feel confident in our abilities. So how to balance both of those goals?
See, resolving cases quickly will not depend only on you. For example, there are issues which relates to listing of the cases. Your cases will not get listed. We face that on daily basis, and even if your case get listed, it will not come on board. Yes, in last week's cause list, there was a judge before whom 982 cases were listed in a day. No, it is not humanly possible to deal with 982 cases in a day. Suppose your case gets listed at serial number 600. That will not come, and again that cycle will continue. Now the client will think that the advocate is not doing anything, and you will have to make the client understand then the procedure, because there will be things which will not be in your control. The listing procedure, the request procedure, that is the domain of the registry, of the court, of the high court, or of any court, of the Supreme Court for that matter. So quickly resolving cases. Now the part which you can do is that if the matter reaches, you argue, you don't take the adjournment. If you take the adjournment, then again it gets delayed. So what you can do is that you don't take the adjournment for unnecessary reasons. If it is not on a very important thing, don't take adjournments. I think that is the thing which you can do, and make the client understand the procedural aspects of the listing. I think this is very important.
Right. So, sir, any final advice for the audience members, if you can?
Can I ask a question before?
Right. We can take one last question. We would love to take all the questions, but due to paucity of time, we cannot. Just please go ahead.
Yes. So how do we calculate and decide which field of law we choose to go to? Because if you say in criminal cases, the disposition rate is faster than in like civil cases, that is, and in MCOP cases, we see a lot of money getting around, and in family disputes, it is completely different for that matter. And how do we come up with a decision in this regard? And if we don't have any like so much interest aligned in one particular field for that matter?
To answer that question, I think we read different kinds of laws. In some laws, we take more effort, and in some laws, we don't take much effort. We enjoy reading them. I don't know which laws you enjoy more, but for example, suppose if you are reading that subject for 5 hours, but you don't get the time, like whether 5 hours have been spent in another law, another field. Even if you are reading it or studying it for an hour or so, you get bored, you get irritated, and much effort is required. Now you see that the law which you are taking much effort in, there is more money. I think that is a misconception. Money is not the aspect you should focus in the starting. Money will come to you, it will come. Have patience. If you are good at that field, if you are not good at that field, you will not get that amount of money, either money or the recognition or the interest, or you will not get the interest in working in that field. So how you have to choose the field in which you want to work in will depend on how much effort you are taking in each of those fields, and then make a call. Don't think that this field is bad, this field is good, that field is bad. Every field is good if you are good at it, if you are interested in. I will say don't think about the money part. Money part, at least in the starting, don't think about it. Just create your ability and credibility. Focus on that. People focus excessively on the money on the initial years, and they focus it and they fail. I have seen them failing. I have seen them. And people who haven't focused on the money part, they have succeeded. I have seen. Focus on creating the ability. When I was working under Mr. Gopal Subramaniam, I asked him, where should I start from? So he told me that I should spend at least 3 years in the trial work, and then I should go for the higher courts. Again, he did not. He again told that money part is not the primary thing which you should focus on. If you're focusing on it, then I think that is going to create the problem. If money aspect is the deciding factor for you to choose the field, I think that should not be the factor. Your interest should be.
Right. I
Sure,
hope it
Pratik.
answered your question. Right. So we come to the end of the session. Thank you so much, sir, for a wonderful session. I'm sure it was very insightful for everyone who was present here. Especially thank you for scheduling out time on a Saturday evening and being with us here today. So thank you once again for everyone present here. Have a wonderful weekend ahead.